you know.
Yeah,
So
thank you all for
yeah.
joining in, and we really are excited to have this opportunity. I know everyone is still, at home, and Ramadan just ended, but we felt that this is a topic that inshallah we can all benefit from. So I'll introduce the subject, our speaker, guest speaker today, Brother Omar Sheikh, and also tell you a little bit about Sharia portfolio. And then, what we're aiming to do is to give the session for presenting, and allow some Q&A time as well. And hopefully kind of, wrap it up, before the end of the hour, hopefully. So again, my name is Ali Radawalji. I am a financial advisor with Sharia Portfolio. Our firm is based here in Lake Mary, Orlando, Florida. We are a full service wealth management firm. And, our main objective is to build customized portfolios for our clients to be able to help them with their retirement, education savings goals, tax savings, and sometimes an often overlooked area is estate planning within the overall financial planning. And so that's why we felt that there was a need to have education around this subject. And we're blessed to have within us, Brother Omar Sheikh, who has a ton of experience in this area. He has been practicing law for 15 years and has a, experience in a lot of different areas that inshallah is going to help us in the discussion today. So I just want to highlight that, this is a topic that, is dear and near to our hearts. And specifically, again, Brother Omar has experience in estate law, purchases, sales, financing, development, leasing, evictions, foreclosures. I mean, a lot of variety of different areas. Also in the areas of property law, with real estate, asset protection, estate planning, litigation. These are some of the areas that, him and his firm have a good amount of experience in. He has also been serving as the board of directors for many nonprofit organizations, such as Muslims for Peace. He's been involved with the Asian American Bar Association, as well as, led in a lot of different other initiatives. So just to give you an idea of his background, again, for those who are new to Sharia Portfolio and are still tuning in, we are a full service wealth management firm. We build customized portfolios, and we are happy to set up one-on-one consultations with anyone looking for a more in-depth discussion about their, financial picture, develop a strategy and a game plan. That is what we are here for. We have a team of advisors around the country, and we would be happy to work with you one-on-one as well. So we'll provide contact information towards the end. You'll be able to see the contact info on how to reach us. But just to give you a quick, our phone number is probably the easiest. Even Brother Umar, you can remember 888 Halal Stocks. I don't think anyone else has something as easy as that. And for email, you can always reach out to info@shariaportfolio.com. So without further ado, we'll get started. Brother Omar, feel free to take it from here. And inshallah, we'll field questions as they come. I would recommend to leave the time at the end, but if there's anyone who has pressing questions, we'll try and address them as we go. Sister Shafaq Qazi, one of our licensed financial advisors, is also here, so she'll be helping answer some of the questions as they come in the Q&A section. But if there's any general questions, we'll try and address those towards the end as well. So inshallah, bismillah.
Assalamu alaikum. Thank you, Brother Raza, for that wonderful introduction. Just wanted to make sure, is my audio working okay?
It's better than before, but I am sensing some audio issues. But let's see, maybe it'll get better.
Okay, let's give it a try. So
be sure to share your PowerPoint, right, Brother Omar?
Oh, absolutely, absolutely. So. So let me do this. Let me say again, I appreciate the introduction, and apologies that my hand is in front of my face. It's just to keep the microphone a little bit closer. So Salahuddin, if you could, it's giving me an indication that the host has disabled screen sharing. So I don't know if you're able to turn that on for me to share the PowerPoint.
You should be. Let me double check that.
So while you're looking into that, let me just give everyone a little bit of background on myself as Brother Ali Rada started. So I have been practicing now about 20 years. I have a background in what I like to deem property protection law, with a concentration both in real estate and tax law. So what my practice does is many of my clients are real property owners that I help in different areas, and that leads to other parts of their lives. It leads to assisting them with setting up wealth management structures from both an estate planning and an asset protection point of view. So this topic, comes close to what my concentration is, and a little bit of background on our firm. Offit Kerman is a full-service firm that specializes in assisting high net worth individuals and small to medium-sized businesses.
Yeah.
We have about 220 lawyers spread out over the Eastern Seaboard. We have attorneys licensed and offices in New York, Pennsylvania, New Jersey, Delaware, Maryland, Virginia, and North and South Carolina. So we are one of the largest, one of the fastest growing firms in the United States, and we are able, in most instances, to service people all over the country. I handle real estate all over the country, and so if you've got any questions, and you're in a state that we don't have an office in, we generally team up with lawyers in your home state to help us with any local issues. So without further ado, let me get into tonight's topic, because we do have a short presentation that I'd like to go through, and then I'd like to leave more time for some questions and answers. And then, like Brother Ali Raza said, what we can do afterwards is provide you contact information for them, and they certainly know how to get in touch with me and filter that through. So first,
you should be able to share your screen now.
All right, let me give it a try. Let's give this a try. Ah, there we go.
Mm-hmm.
Perfect. Okay. Did that work? You guys can see the screen?
Yeah, if you click, Brother Omar, at the top, that the button that looks like a cup at the top, utmost next to refresh.
Okay, good.
Yeah, then I'll show the whole screen.
Perfect, perfect. So, okay. So first question is, what is estate planning? When people talk about what estate planning is, what exactly are the goals of it? So the first thing is, it is a system through which we can, where you can designate how you want to dispose of your assets. These are assets that you've built up through your entire life. And so why should you lose control of them once you pass away? And the hard part with estate planning is, many people believe that, look, I'm way too far away from death, right? Why, I can plan for that later in my life. It's too early. But, as we see with the COVID-19 situation, the hard part is you never know when you're going to be taken from this world. And unfortunately, we've seen too many times where...
Omar, sorry for a second. I think we are only seeing half your screen for some reason.
Let's see here.
Half the presentation. I think it's getting cut off.
Let's try this again.
Nope, it's cutting out. It's cutting off your PowerPoint.
Yeah, at the top,
Uh,
if you look, usually there's the button that says View Full Screen. You know, that next to the refresh button, I believe.
Mhm.
You know, there is yeah, that one. I
Yes.
think that's the one. Or if
okay.
I'm not mistaken, it's still cutting it out, huh?
Oh, oh,
Let's
we can
try
still
like,
use, yeah.
Yeah, maybe don't share the full screen. Just let's go slide by slide because we can still see this way, and it's visible even without the full screen.
okay. That works okay like that?
Yeah, yeah.
Yeah.
This
Okay.
this works good. Yeah.
Okay, let's do that then. So like I was saying, in what we don't know is when we're going to be taken from this world. And um, the other thing with estate planning is a lot of the planning tools that are available sometimes depend on the timing with when you enact them. So, for example, one of the most popular planning tools nowadays is what's known as Medicaid planning. And with Medicaid planning, one of the things that we try to do is we anticipate in the event that someone's going to need long term care and they want to protect their assets for their family, but in a manner where the government will end up paying for their health care in that long term. Well, you know, if you want to take advantage of Medicaid planning, you have to dispose of your assets to your family members at least 3 years before you need the Medicaid. So a lot of times, what happens is people come to us and they have a sick family member, that's already incurring medical bills. The problem becomes is Medicaid planning does not work in that point of view. Medicaid will first demand that you dispose of your assets towards those medical bills first. So, so that's one aspect of estate planning, that you get a chance to plan how you want those assets to be disposed. Next, estate planning can save your heirs time and expense from both court procedures and also, battles over your assets. It is it's a situation where, after you die, you may have communicated to your family members how you want those assets disposed, and not through anybody's fault, but sometimes people hear different things and they have different memories as to what you may have wanted. And unfortunately, even if we leave the family members aside, in some instances, there may be court procedures that they then have to go through that may have been avoided if you had an estate plan. So, for example, and we'll get into this a little bit later, if you pass away without a will, the first thing that has to happen is someone needs to go to court and get appointed to be able to transfer your assets legally. That process can sometimes be very lengthy, depending on how many family members you have and how cooperative they are. But in some instances, a court may also require you to post a bond, which may pose some type of financial stress on the family at the most inopportune time. So that's another reason for estate planning. And the third, is the potential to save on taxes. We'll see this a little bit later, but there are limitations as to how much you can pass in assets, before taxes are applied to them. So, sometimes with a little bit of planning, your heirs can be saved from those taxes and they can enjoy the fruits of your labor without having to pay Uncle Sam. So, like I was talking about, why is estate planning important, right? First, to make sure your assets are protected. Everybody's worked hard accumulating their wealth. And what we don't want to have happen is a situation where, your family now needs to liquidate those assets to continue living in the same lifestyle that they've enjoyed while you were alive. Second, it's a way to provide for future generations. You know, some people have, done very well in their life, and look, they may understand my children may not do as well for a variety of reasons. Maybe you got lucky in business. Maybe your kids don't want to run the family business. Maybe you have a special needs child or a special needs person in the family that you need to provide for in case you are not there anymore. And number three, once you have estate planning, um, you know, there's an initial setup. You may change your mind. or because of tax law changes, you may find that you may need to make changes, as you go along. But those changes over the course of time then become much easier as opposed to starting fresh on an estate plan. Now, what happens, I'll go over a little bit about what happens when you don't have an estate plan. So if you pass away with assets and you don't have a will, now this slide is particular for New Jersey, but almost every state, and I would say, has what's known as an intestate distribution system that regulates how your assets are going to be distributed in the event you don't have a will. Some people may be fine with this, some people not. But an example in New Jersey is your spouse will get the first $50,000, right? And then whatever's remaining, one half of that. The other half will be distributed to your children, right? Now, you may have a situation where you have young children, right? Your spouse may need that money, but the state's going to decide that that money should go into trust for your kids, right? Or you may not like your children. You may want your wife to get all the money. Well, the state here is going to tell you, well, the kids have to get it. And that gets back into, what I was talking about before, that there may be court battles here, right? Your wife and your children may be, and I shouldn't say wife, your spouse and your children may be fighting over who gets this money. And if you see in the last portion of the slide, let's say you have no next of kin and you were planning to give all your money to a local charity or a masjid or something like that. Well, you know what? The state's going to say, nope, we take that money. So that's another reason why, we counsel everybody when you know where you want your wealth to go, that's when to set up your estate plan. And if you don't, well, you should get in and start talking to somebody to figure out where you want it to go, because it may go somewhere that you don't want to be, right? Now, some people will tell you that, unless you have an enormous amount of wealth, you don't need to do estate planning. And, in some instances, that's a fair statement, right? So on the federal level, right, we have what's known as a basic exclusion that this year has been increased to 11.58 million. Now, what that means is you have a lifetime exclusion amount. And during your lifetime, you can pass via gift or through your death up to $11.5 million before estate taxes are applied. Now, if you do it through your life, right, it's known as a gift. And there's no tax when you make gifts up to this $11.5 million. And it can be a nice tool to transfer assets during your lifetime. But you do have to report those gifts to the IRS. They keep track of it, and it comes off of this $11.5 million number. And whatever's left over, then it gets used up when you pass away. So some people say, well, I don't have $11 million of assets, so why do I need to do any estate planning? Well, there's also the state tax level, right? Now, New Jersey has no estate tax. New York, on the other hand, that exclusion amount is 5.85 million. So if you're in a situation where you don't do any estate planning and you have a $7 million estate, right? Well, you might have protected yourself from the federal tax, but you're going to get hit with a New York tax. Now, I know we have people from all over the country on this call, so this is something that you need to check, right? What is the estate tax that I have to deal with in my state, all right? Now, I just showed you that New Jersey has no estate tax, but, New Jersey comes around the other way. They don't tax the estate, they tax the beneficiaries that get the money from the estate. And New Jersey has designated beneficiaries in different classes, right? Your spouse, your children, your parents, they don't pay any inheritance taxes. But if you're going to give any money to your brothers and sisters, right, or other beneficiaries, they're going to pay a hefty tax before they get something. So if you have $100,000 that you're giving to your brother, right, 75,000 of that, he's paying about 15% tax to the state before he can touch the money. And again, through a little bit of planning, sometimes this can be avoided. Right? And we see this also, now we get into, a little bit of the Sharia component of these things, right? We live in a system where, you know, we have to abide by state and federal laws when it comes to taxation. And at the same time, many of us try to be Sharia compliant as well. Well, you know, in some instances, Sharia estate planning and US tax laws fit well, very well together. But without some type of written instrument to dictate what you wanted to have happen, you're going to fall back into a state deciding that you didn't have a plan. If you pass away and your heirs show up and say, well, you know, my father or my mother wanted to distribute her assets under Sharia law, there's no court in the United States that's going to listen to that. Why? Because courts require a written will as a method by which it will be demonstrated that that was the wishes of the person who passed away. And a will under state law has different requirements. Some states require that it be witnessed by 2 people, sometimes 3 people. There are particulars in terms of the language that we have to use. And so whether or not you want your estate plan to be Sharia compliant, right, you still need to follow those rules. Now, what does Islam require, right, from your disposition of assets? Number one, that all your funeral and burial expenses are paid. Now, I will tell you that from a state law standpoint, right, almost every will that we draft, right, provides that right off the bat, funeral and burial expenses will be paid from the person's estate. Why do we provide for that? Because state law mandates it even if we don't. It has to be paid from the estate, right? So in that respect, Sharia planning, US planning, exactly the same. Number 2, all debts of the deceased have to be paid. Again, this is somewhere that, you know, Sharia planning and US planning provides the same. Before beneficiaries can receive assets under the US system, the debts of the decedent have to be paid, right? Again, now, a little bit of a difference between Sharia planning and US planning. You know, in some instances with a little bit of planning, right, you can dispose of your assets during your lifetime. And if you have debts, they can be left nowhere, right? From a Sharia standpoint, you'd want to make sure these are done, right? Now, what is the next step in Sharia planning, right? And I will preface my comments here by saying, I don't know who we have in the crowd, and I do not profess to be an Islamic scholar, all right? I'm a legal scholar and I'm an attorney, and the information that I'll give you next will change depending on your particular beliefs. So on some of the Sharia planning, the way that we handle it in our office is we tell you that, look, we'll give you the guidelines. But what we'd like to do, right, is work with either yourself, if you're familiar and knowledgeable yourself in terms of Sharia planning and what your beliefs are, or we're happy to work with your imam in your local mosque or wherever you decide to. Because some of these questions get complex on some of the planning as to what's permitted and what's not permitted. And so we don't profess to tell you what to do or how to handle it. Now, take this for example. So under Sharia law, generally, your estate is split into 2 buckets, like I like to say. The first is 2/3 of your estate, right? And that's known as the non-will portion. That 2/3 of your estate is dictated under the Quran how it's to be divided amongst your heirs living. And there's a portion that will go to your spouse. There's a portion that will go to your kids. There are different rules as to between sons and daughters who's going to get. There are different rules as to what brothers and sisters and grandparents and all these other different categories as to who's going to get what. And because of that, if you want your non-will portion to follow Sharia planning, now it becomes even more important to do estate planning from a tax point of view, all right? Because like we saw, New Jersey taxes beneficiaries, New York, the federal level, they're going to tax assets. And I'm sure that everybody wants to maximize the amount of money that is going to their beneficiaries. And so sometimes, look, we can't avoid the taxes depending on your situation, but we at least want to try to plan for that way. And then you have the other 1/3 bucket, which is your will, right? And this generally can go wherever you want. Some people believe that it can go anywhere you want, except for the people that have to get under the 2/3 portion. Some people don't. Another difference in people's beliefs, right, is, that any estate planning, Sharia or state law compliant, is that it only controls the assets that you have when you pass away. So some people say, well, if I gave away all my assets during my lifetime, I don't have any assets to abide by this, right? From a religious point of view and a moral point of view, some people would argue that it's fine if you gave away your assets knowledgeably during your lifetime, but if you did it solely to avoid your obligations under the Quran, that's not so good. So again, I'm not here to tell you what to believe or what not to believe. I'm just giving you different sides of the equation to think about for yourselves and discuss with your imam, right? So in some instances, people will say, I'll put all my assets into a trust. I don't own anything. I don't have to follow these rules, right? For some people, that doesn't work so well. So now, what are some of those particular rules, right? I mean, I think anybody can go to the 4th Surah, 11th ayah, and you'll see them, right? That the way these things are broken up is very clearly laid out in terms of percentages. You can go online and do an Islamic will calculator and put in how many brothers and sisters and kids you have, and it'll tell you the various percentages that people are supposed to get. Some people, again, depending on your faith, are very happy with the way this turns out. Other people, not so much, right? So, but again, that's dependent on your faith. So, and then there are sort of like how we saw some state laws, define people in different categories, right? Under Sharia, it's kind of done the same way, right? Now, what are some of the tools that we use to do estate planning, right? So there is your last will and testament, right, which is supposed to govern three things. Number one, it's supposed to govern who you're directing your assets to. And those are assets that you have when you pass away. So they'll be defined generally, so that, the will doesn't have to be updated every time that you have an asset. Normally what we do is we lump personal property into one category. And number two, what your will do is it will define who the executor of your estate is. Who is the court going to put in charge to dispose of your assets? And as I was talking about before, some courts, impose a bond requirement on the person in control of your estate to make sure they don't abscond with any of your money. So in your will, you can designate that I trust this person, and I'm telling the court that they don't need to furnish a bond to the court. Number three, if you have minor children, your will can provide who you want the guardians of those minor children to be. And, that's one of the things I tell a lot of people, that even if you don't have a lot of assets right now in your life, and you don't think you need the estate planning, it's the minor children that you have to think about now. Because otherwise, if you and your spouse don't designate who you want those guardians to be, that fight can be much worse than fighting over assets. And it's the children you've got to think about. So other tools that we have are trusts, right? So what's a trust? Very generally, a trust is a separate legal entity that you establish the rules for. So for example, if you want to set up a life insurance trust, right? You're going to buy life insurance for your spouse. We may recommend that, the life insurance be owned by a trust. Why? Because then the value of that life insurance is not calculated in your estate from a planning purpose. So if your life insurance starts increasing in value, that does not get onto you from a capital gains perspective. And it also doesn't count towards this $11.5 million or the $5.5 million that we were talking about, where before taxes are triggered. So The trust owns the life insurance. You put the premiums in, the trust pays those. And then when you pass away, the trust then governs where this money is going. You can designate the trust to be the beneficiary, to continue to hold the money and invest the money for your children, for their education, for your spouse, for their well-being. You can designate that certain amounts of money go out of the trust at a certain period of time. And, this way, if you have concerns about your wealth after you pass away, in your lifetime, you can set those rules. Number 3, family limited partnerships. These are used a lot, to transfer businesses or transfer wealth between family members. So for example, getting back to this $11.5 million lifetime exemption that people have, on the federal level, if you have a business that's worth $20 million, right, during your lifetime, you may want to transfer portions of it to your children. I talked a little bit before about gift tax, right? Gift taxes have to be reported to the IRS, but the law also allows that on a per year basis, per gift recipient, you can donate up to $12,000 per year without even reporting.
Actually,
So
Brother Omar,
Yep.
Brother Omar, I think it's 15K, right? If I'm not mistaken.
Oh, you might be right. You might be right. It might have been increased to 15K. So, so $15,000 per year
Right.
per recipient, right? So
Right.
if you've
So
got
between
4
husband
children,
and wife, for example, and this is a common thing that we sometimes do get asked with accounts like the UTMA, which is a trust account that's set up for the benefit of the child, right? For education savings or for whatever long-term goals that you may have for your children. Some parents decide to consider doing a UTMA for them. And this is a question that sometimes does come up. So generally we tell them that, look, between the two parents, you can put up to $30,000 in each child's account. That may sound a lot, but if you think about the cost of college, 4-year institution can rack up to 150,000. And if you have young children, like I do, then, it may be even more. And, we want to, encourage them to go for a higher level. So it does help to kind of know what these limits are. And correct. And Brother Omar, why don't you talk about how this can also be a way to, for some really high net worth individuals, this is another mechanism that can help transfer wealth and also not be included in that 11.5 million. Maybe you can touch on that as well.
Yeah, absolutely. Because, it's a very powerful tool because it allows the transfer without any reporting to the IRS. So as we were saying, if you're talking about $15,000 per husband and wife per child, right? If you have 4 children, now all of a sudden that's $120,000 of wealth that you can transfer, right, on a per year basis. And, depending on how we set up the family limited partnership, right, so I'll give you a quick example, right? So if you have real estate, right, and that real estate, you have 2 buildings, each building is owned by a separate LLC. From a valuation perspective, if you are going to transfer $120,000 of the value of that LLC, you're transferring minority interests in the LLC. So from a valuation perspective, you're able to transfer more shares in the family limited partnership, right? While at the same time keeping the value of those things extremely low, right? So, you may be able to designate, over a 10-year period, being able to transfer enormous amounts of the wealth of this family limited partnership without triggering any kind of tax or any kind of implication on your $11.58 million exemption. Now, what sometimes goes in with those, right? So family limited partnerships, they kind of assume that, you own everything, and husband and wife are transferring to the children, but not necessarily. And sometimes we use the next tool, which is a buy-sell agreement. This may be if you have, a partner in a business, right? So if you've got a partner in a business and you own it 50-50, right? Well, okay, what happens if one partner dies, right? That other partner is going to say, well, look, I want to buy you out, right? Have you and your partner designated what the value of that buyout is going to be to protect your family, right? Otherwise, the family is going to get into a fight with the partner or say, look, now I'm part of the business, all right, which may cause issues with the business or whatever. So that's another thing that has to be dealt with early on so that the family is protected based on the value, right? And we've seen too many times where one partner passes away and because of a fight, now the next thing you know, the business is kaput, right? Where, you know, a partner is going to, you know, basically destroy the business so that the family members of his deceased partner don't get anything. It happens, unfortunately, right? And then the last planning tool, and it's not the last, but you know, the last one I'll touch on is life insurance as a funding source. Now, for some people, this is not, life insurance is not Sharia compliant. For others, it's fine, right? But you know, one way to use life insurance as a funding source is if you anticipate taxes, right? Same thing. You don't want your family to have to liquidate assets in order to pay taxes that are going to be due on the estate, which keep in mind, right? They're going to be due 9 months after you pass away. And so, you know, sometimes life insurance can be a very useful tool in order to protect the family from having to liquidate assets in order to pay taxes. So now that's all I've got for today. So I hope it's been informative. I know it's a lot of information packed into a short amount of time. And so I'm happy to answer any questions right now, or, you know, if you have questions later.
Thank you so much, Brother Omar. I will just touch on a couple of things that may be beneficial, inshallah, for everyone as well. Sometimes a question does come up with regards to if we want to go ahead and update or prepare a living trust, right? And that's something that, you know, Brother Omar and attorneys will often work with individual clients, look at what your specific Islamic will, you know, has whatever provisions are in there, and then draft a legal document that can hold up and kind of protect you and your family's assets better. So once you've established that living trust, sometimes a question comes up is, well, how does that, you know, what needs to be done with my assets? So oftentimes, you know, we'll tell individuals that, you know, you can go ahead and update the beneficiary to reflect the specific trust that you've established. So if you've worked with an attorney, you know, now you have a much more powerful document. Rather than just listing out beneficiaries and percentages, you have a better document that can now be updated, you know, as part of your estate planning, but also for the beneficiary purposes. So just wanted to kind of touch on that, and it can be a work in progress, you know, as he mentioned, you know, whatever you incorporate in your trust, you know, if things change over time, that can be a dynamic document that can be updated depending on what is in there. I know one thing you also mentioned that I like to just briefly touch on, especially, you know, that's often sometimes not a subject that I've seen covered by, you know, our non, you know, masajid and other entities that, you know, it might just be that we need more education on this subject is the area of special needs trust, right? Brother Omar, I saw a point you had highlighted in there. And just to bring a brief point around this topic, because we do often have friends or family members that we have met that have you know, someone in their family that has some kind of special needs, and there are different laws surrounding the, you know, the benefits that they receive and how to protect those benefits, you know, who to designate as a trustee, how the special needs trust is established, and then also, you know, working with the custodian and what the requirements are. So there is a lot to it, and some people may decide, look, they want to do everything themselves. And you know, if you do choose to go with this, you got to be more or less versed with the legal criteria behind what it takes to administer the trust, set up the trust, and do the ongoing reporting and things of that nature. So yeah, maybe you can touch on a little bit about that as well. But I just wanted to briefly mention that this is an area that I'm seeing some parents asking about, and you know, I'm sure it could be a separate presentation as well. But if you have any other pointers you want to throw in about that, you know, feel free to do so, Omar.
Yeah, I mean, I think I'll answer the question this way in saying that, you know, there are a numerous amount of different quote unquote normal trusts that can be established, right? All for different purposes, right? So you have, a special needs trust is designed to benefit children that you can foresee in their adult lifehood are going to need special care, right? So whether it's medical care, whether it's in terms of employment assistance, whether it's any of that type of care that you may not be able to provide for once you leave the world, that's designated specifically for them. And other types of trusts, sometimes you have grandparents with a great amount of wealth. One of the types of trust that we will try to set up would be known as like a generation skipping trust, right? And there are tax reasons for that if you give directly to your grandchildren. But I would say generally with trusts, one point that you made, Ali, rather, that I think is very important for people to keep in mind is there is an administrative side to the trust, right? Not only do you have to designate a trustee, which sometimes can be, yourself in some instances, sometimes can be a family member, but in other cases, you want to designate an institution to function as your trustee. For a variety of reasons. So, and different trustees can have different powers, right? So also, your trustee can designate specific people to, administer different portions of the trust. Like, for example, it's not uncommon for a trustee to say, hey, I want you to be the financial advisor to this trust. And protect the assets in that way, and give, maybe not with some, delineations as to, what the goals of the trust are, but a lot of times we leave that up to the trustee because things change over the years. So we don't want to tie the trustee's hands right off the bat. So I hope that answers the question.
Yeah, no, thanks for chiming in and shedding some light on that. So what we will do at this point is field some questions. I do see there is a general question here that was posed. When talking of Medicaid, I believe the Medicaid will only give if you have no resources or assets. But if somebody has $2,000 in Social Security income, will not that be enough to disqualify somebody from Medicaid, even with no assets or 401k? So what do you say about that?
Okay, so I don't know the answer to off the top of my head. My understanding is that Social Security benefits will not disqualify you from Medicaid.
Okay. The other question then is, if somebody has balances in a 401k plan, can they transfer? They cannot transfer their IRA to 401k plan to such trusts for Medicaid planning. Is that also something that you have information on, Brother Omar?
I'm sorry, ask the question again.
If somebody has balances in their 401k plan, they cannot transfer their IRA to their 401k plan to such trusts for Medicaid planning. So maybe the question may not be as clear, but I don't know if you...
It's IRA or 401k plan.
IRA or 401k.
Or 401k. Okay. So as a general rule, in order to access Medicaid money, you cannot have any of those assets available to you.
Okay. All right. And then, how are capital gains handled on inherited properties?
How are capital gains? Okay. So the person inheriting the property is going to get the benefit of what's known as a stepped up basis. So basically the tax basis not the tax basis, but the fair market value of the property when it's transferred to them. And if you think about that from a fairness standpoint, this way the person, once they inherit the property, only has to deal with appreciation from that point forward.
Okay. All right. Looking at the other ones, I think some of those are more specific that I would recommend, if there's more specific questions, these can be directed, and you guys will have the contact information for the Umar. You can reach out to his team. If it's an attorney related question. But is there anything that Shafak you're noticing that has come in? And Salahuddin, also, if there's any people who are tuning in through our Facebook page, if there's any specific questions, feel free to let us know, because we do have a few minutes here. One question that has come up is, if our financial accounts or real estate property has a beneficiary listed, will that protect our assets from probate, basically?
So generally, yes. So assets that have a designated beneficiary will pass without court involvement. So, for example, if you own your house, husband and wife, if one spouse passes away, it automatically transfers to the other one. Any account designated as joint with right of survivorship, that will pass without probate. If you have designated beneficiaries on your accounts or your 401ks, those also pass without probate. And so that's also one of the tools that we use when we're estate planning, is to see what is left.
Okay.
And then some people would like to know if Brother Omar will be sharing the PowerPoint with them.
I don't have an issue sharing the PowerPoint, with the disclaimer that it's general and doesn't apply to everyone, and that everyone should seek out an attorney to answer any specific questions.
All right. What are resources to use as calculators or for the most current IRS or state rules? Is there a link that does list, a segment that people can visit the most up-to-date rules on this? I'm sure it's constantly changing, so I don't think there would be one place for all of this, right?
Not that I know of. On a state-by-state basis, you can generally look up the tax rates in your state, and it'll also give you that maximum amount before state taxes are applied.
Okay. When a spouse dies, does the other spouse own the home, or should the value be distributed to the spouse and children under Islamic law? So they want to know under Islamic guidelines. So I know Brother Omar had mentioned in the beginning, there are two buckets that generally are to be distributed and to be kind of delineated. And in that, you can follow, again, whatever the guidelines of your local imam are, and according to that, the attorneys can draft accordingly. But do you want to shed any additional light on that particular question?
So that's a good question, right? So one of the ways to
I think your audio is a bit low, Brother Omar.
Is that better?
Yeah.
Okay. So there's two ways to look at that, both Islamically and legally. So number one, if husband and wife own the house together, some imams will tell you that because of the immediate transfer to the other spouse on death, right, that it operates such as like a 401k with a beneficiary, and there is nothing left on death to distribute. Other imams will tell you, no, the house has to be split according to Islamic guidelines. So that's why, again, getting back to what Brother Ali Rada said, you want to consult with your local imam and your own beliefs as to what happens in that situation.
Great. And we will be sharing the slides, but someone has requested if you can show slide 9, please. If you can currently show that, that would be great. Otherwise, as we are getting that loaded up, we also just want to remind everyone that, for those who do want to discuss your personal retirement, education goals, investment for long-term savings, ShariaPortfolio does have a comprehensive solution that is tailored to each individual investor's needs. So I would encourage everyone to schedule. You can go right to our website and schedule an appointment directly with one of the advisors. In addition, there's a lot of resources that we do blog about in our blog section or in the news that hopefully can benefit you and your family. So feel free to follow us on our through our newsletter if you haven't subscribed, but also for our social media channels. I just wanted to bring that up. Let's see, any other questions that have come in? All right, looks like Most of them we have addressed. One person did ask, should all stocks or IRA 401k be transferred to trust? I think we did address that we do want to recommend that as something that you have a trust updated. And it's not just to protect your assets, but as Brother Omar highlighted, you also want to make sure that you want to protect your children should anything happen. So, that is a recommendation that was mentioned. Any other questions here?
I think someone requested slide 9.
Slide 9. Yes, Brother Omar, did you get a chance to put that up?
It should be up if you can still see my screen.
We're not seeing the slide 9.
Yeah, in general, we will share that. So whoever is requested, don't worry. We will share the presentation. We also have something that has come in. If someone has an irrevocable trust, are they able to make changes to this trust that will be legally valid?
That's a very good question. And the answer you're not going to like is it depends. And it depends how that irrevocable trust was set up. Sometimes we have an irrevocable trust where there's a trust protector that's named, and sometimes that trust protector has the ability to make changes. In other instances, and again, this also depends on what state you're in. With the consent of beneficiaries, we can make changes to irrevocable trusts, but the trust itself would have to be reviewed.
All right, thanks for that. So yeah, for those, because that is something that I have thought about as well in the past, because when they say irrevocable, it pretty much means whatever you're putting in there, that's it. But I'm glad to know that there's always an exception to the rule, right?
No, there's many times exceptions, and in some states the irrevocability basically means that the person giving it can't take it back, but
Okay.
sometimes the rules governing the trust can change.
Makes sense. And for those who are asking, the recording will be available. So for those who have attended, the link will be available. So, you'll be able to, if you joined in a little bit later, you'll be able to benefit from the beginning as well. But we hope that this kind of informational sessions are beneficial for you and your families. We also hope that if you have any topics of suggestions, please do let us know. We will be happy to kind of plan along and provide good educational programming for everyone. And again, at the end, there's a slide Salahuddin can put down for anyone who wishes to contact us, either Brother Omar Sheikh directly and his team to be able to assist you with your estate planning needs. And then on our personal level with ShariaPortfolio, for those who want to learn more about our service offerings and to be able to discuss your personal financial goals, you're welcome to reach out to me and Shafak, who is also on the line, and any of our advisors as well, who will be happy to assist you. With that said, looks like I believe we have addressed all the general questions here. And then for anyone who has any other questions outside of what has been submitted here, please do let us know, and we will inshallah address them with you one-on-one. Yeah, thank you once again, Brother Omar. Thank you everyone for attending. We wish you and your families safety, especially in the current environment. Please stay safe, and look forward to reconnecting with you guys here soon, inshallah.
Thank you so much.
So.
Assalamu alaikum.